Greetings, everybody. Good evening, good morning, whichever jurisdiction you are. Welcome to Semifinal Day 1 of the Greenlaw Global Initiative, Climate Justice International Moot Court 2026. Before we proceed, I'll give the IT team, Simon, to lead us in a virtual group photo. Simon?
Thanks a lot, Dr. Brian. Kindly let us open the cameras so that we can have a photo. Yes, kindly let us open the cameras. We have Kimani, Seth, Lauren. Kindly let us open the cameras. I'll be taking the photo in 1, 2. Fantastic. Thanks a lot. That's all.
Thank you, Simon. My name is Brian Amonda, and I am the court assistant for this session. Welcome to the semi-final round 1 of the Greenlaw Global Initiative Climate Justice International Moot Court competition. The matter before this honorable court is between Catholic University of Eastern Africa, representing Azania, versus Jomo Kenyatta University of Agriculture and Technology, representing CECA. The honorable bench for the semi-final session consists of Lady Justice Ellen Omondi presiding, Justice Matthew Emukule, and Justice Antoinette Ogange. Before I hand over the proceedings to the honorable bench, participants, remember the format of the semifinals, which was given unto you. We indicated the semifinals will take a different format. Consequently, each side will have 3 minutes at the opening to put forth their case theories. After the 3 minutes are up for each side, the bench will engage the counsels in questioning, and each side will have 10 minutes to respond to the bench. Then the mandatory concession segment, where the presiding judge will ask 2 questions for that segment, will take 5 minutes each for each side. Then the judicial hypotheticals, where each judge will be required to pose at least 1 hypothetical question to counsel to see if the counsel's legal standing survives, will take 10 minutes for each side. Then the rebuttals will take 90 seconds for each side, where the presiding judge will ask a single question. I now respectfully invite the honorable judges to take over the bench. The court is now in session. I respectfully invite the honorable. Was I able to be heard? Simon?
It's loud and clear.
Can you hear me?
Yes, presiding judge, we can.
Thank you. Thank you very much, and a very good. Thank you, and a very good afternoon, good evening. We are now in session. The bench has already, and I will invite the court assistant to call upon the counsel that is representing Azania.
Thank you very much, presiding judge. Counsel representing Azania, remember you have 3 minutes to put forth your opening statement. And in your opening statement, we look for the legal theory, your prayers, and all that was indicated unto you. So counsel representing Azania, your 3 minutes starts running now.
I am well guided, and thank you. Presiding Judge and Your Excellencies, my name is Nick Kimathi, the lead counsel for Azania. I am joined today by my co-counsel, Mr. Kamore. Your Excellencies, allow me to borrow the words of the 2025 ICJ Advisory Opinion, where at paragraph 393, the court is of the view that a clean, healthy, and sustainable environment is a precondition for the enjoyment of many human rights, such as the right to life, the right to health, and the right to an adequate standard of living, including access to water, food, and housing. The right to a clean, healthy, and sustainable environment results from the interdependence that exists between human rights and the protection of the environment. The state of Azania bases its enactment of the TWCCA on its international obligations set in international treaties and instruments. In addition, reliance is on clarifications by courts on the obligations of states in relation to climate change and environmental protection. Indeed, national courts like the Dutch Supreme Court in the Agenda Foundation 2019 case and the international tribunals indeed have affirmed this. It is the hope of Azania that the African Court shall follow suit in an advisory opinion requested by the Pan-African Lawyers Union on the obligations of states with respect to the climate change crisis. Azania has done what is reasonable and justifiable for the general good of the people of Azania and the environment. Azania regulates and seeks to impose measures that are in line with international human rights law, as well as important environmental principles of prevention and necessity. Specific measures in the Act, such as the EPR and the digital traceability, are not only proven standard environmental practices across the globe, but the most effective practices. Allow me to use the words of a world-renowned Kenyan environmental and political activist, where at her Nobel Peace Prize receiving lecture in Oslo, Norway, on November 2004, she uttered as follows: "Today we are faced with a challenge that calls for a shift in our thinking, so that humanity stops threatening its life support system. We are called to assist the earth to heal her wounds, and in the process, heal our own. Indeed, to embrace the whole of creation in all its diversity, beauty, and wonder, recognizing that sustainable development, democracy, and peace are indivisible is an idea whose time has indeed come." Moving on, I cede floor back to the honorable bench.
Thank you. Presiding Judge.
Thank you very much. Let me just inquire from my colleagues up to that point. Judge Ogange, anything that you'd want counsel to perhaps address in the opening?
Thank you, Presiding Judge. Nothing in the opening statement.
Anything that you'd want counsel to address in the opening statement?
No, not at this point, Presiding Judge. Thank you.
Thank you. Then we will invite counsel for CECA to just make opening remarks.
Thank you, Your Excellency. My name is Kamara Castro, appearing on behalf of CECA together with my co-counsel Levis Carrera Ndegwa. Your Excellency, before I proceed, I would like to make a point of correction with kind indulgence from the court. You referred to Carrera to have been submitted, but I humbly submit that Mr. Carrera appears for CECA. A point of correction, Your Excellency.
I am very sorry. That was Nick. Was it Nick?
Yes.
I am very sorry. It's Nick Kimathi.
Thank you, Your Excellency, for that.
Thank you. And you may proceed.
Thank you. Your Excellency, with the 3 minutes presented to us, I will take 1.5 minutes to address the legal theory, the core issue, whereas Mr. Carrera will address the principle and the remedy we seek in the next 1.5 minutes. Your Excellencies, the matter lodged before you today to provide an advisory opinion is presented on one cornerstone. Can principles of climate change law get rid of other principles of international law, including international trade law? Your Excellency, the legal theory we present before you today is to strike a balance between conflicting areas of law, and this includes environmental protection vis-a-vis, Your Excellencies. When there are conflicting points of law, as previously adopted and held by the ICJ advisory opinion on climate change under paragraph 164, then there is need to adopt an interpretation that gives compatibility to different set of rules. Your Excellency, we submit that the decision by the state of Azania remains skewed to the informal sector, and it kills the economic interest of the people of Azania. To this extent, we submit that there is need for the court to strike a balance between conflicting economic interest and environmental protection. I beg now to cede the floor to my co-counsel, Mr. Carrera, to address the principles and the remedy that we seek before the court. Thank you.
May it please this honorable court, my name is Carrera Levis Ndegwa. I am the second counsel representing CECA. On to the legal principles that we intend to rely on. First of all, we do acknowledge that we actually concur with opposing counsel that indeed it is time for us to actually change our ways of thinking and our ways of doing things based on the legal issue that is before this honorable court today. The first principle that we intend to rely on is the principle of sustainable development, which is principle 12 of the Rio Declaration. It has further been mentioned under Principle 5 of the Rio Declaration and under Principle 25 of the Rio Declaration that peace, development, and environmental protection are
Your time is up.
Much obliged.
Presiding Judge.
Thank you, court assistant. So both teams, you have already been briefed on the approach that is now adopted at this stage, and I will then invite my sister, Judge Antoinette Ugange, for interrogation. Judge, do you have any issues you'd want counsel for Azania to respond to?
Thank you, presiding judge. From your opening the state of Azania, counsel for state of Azania. From your opening, the court could hear you making reference to sources of law which has given rise or have given rise to the dispute before these courts. So I want to begin with the very basics. Can you identify the exact source of law imposing a positive obligation on Azania to regulate this sector? That would be my first question.
Thank you, Your Excellency, for that question. And in response to the same, the source of law that has informed a positive obligation on the state of Azania stands to be the advisory opinion that has been rendered by the ICJ at paragraph 281. I hope I have responded satisfactorily.
Mr. Kimathi, we are talking about the basics. What are the sources of law? We need to know that you understand the basics. For example, you have spoken about customary international law. Would you wish to make another attempt?
I may seek clarification on your question, Your Excellency.
When we go to class, we're going to the basics. We learn the various sources of law. Isn't that correct? So
Yes.
the dispute before the court is guided by some sources. I have given you one, customary international law. Do you know any other?
Yes, I am aware of other sources of international law.
Yes, please proceed.
We have international treaties and conventions. We have judicial decisions as well. And these are exhausted under Article 38 of the Statute of the ICJ.
Okay, thank you for that response. Just as a follow-up, do you know of any authority or treaty provision which recognizes the positive due diligence obligation to regulate the private sector in order to prevent harm? Any that comes to mind?
Thank you, Your Excellency, for that question. Allow me to make reference to the Rio Declaration.
Which principle of the Rio Declaration?
Particularly principle number 2, where
Yes.
states have, in accordance with the Charter of the United Nations and principles of international law, the sovereign right to exploit their own resources pursuant to their environmental and developmental policies, and the responsibility to ensure activities within their jurisdiction or control do not cause damage to the environment of other states.
Okay, that is fine. Do you know any authority in support of this assertion that you wish to rely on?
Yes, I would like to make reference to the pulp mills case.
Yes, the facts and the holding.
The pulp mills case is a case where the states of Uruguay and Argentina had entered into an agreement in the form of a treaty where no unilateral undertakings were to be made by any of the two towards establishment of pulp mills on the river Uruguay. However, that same agreement that the two countries had entered into was violated by the state of Argentina. It was violated by the state of Uruguay, and Argentina thus lodged a case against Uruguay. And it established in the said case that states are required to use all means at their disposal to ensure that activities within their jurisdiction or territory do not result into harm of the other state's environment.
Okay, thank you for your responses. Presiding Judge, thank you. That is all.
Thank you, Judge. I will then invite my brother, Judge Emukule.
This question goes to Azania and is purely hypothetical. Supposing Azania had strengthened its pre-existing laws on management and import regulations on second-hand clothes, would it have been necessary to enact the Textile Waste and Circular Economy Act?
Thank you, Your Excellency, for your question. In response, the state of Azania takes the position that it will not have been necessary. A reason being, it is more expensive for the state of Azania to implement a better waste management system. Allow me to make reference to a report by the World Bank titled "The Municipal Solid Waste Cost Calculation and Technical Guidelines for Low and Middle Income States." In this particular report, it is set out that for a waste management system that serves a population such as of Azania's of 48 million, it will require an initial cost of between $1.1 to $5.5 billion and an annual recurring cost of $0.9 to $1.5 billion to keep the same waste management system in good operation. It is not environmentally sound nor economically viable, taking cognizance that the state of Azania is a low-income state. In addition, having demonstrated to the court in the Brazil retreaded tires case that the ban on the import of retreaded tires was necessary, the panel of the World Trade Organization appellate body found that as per the Article 20 of the General Agreement on Tariffs and Trade, the measures undertaken by Brazil were indeed necessary and justified.
Thank you, Counsel. That'd be all from me, Presiding Judge.
Thank you, Judge. The argument presented by CECA is that importing used textiles promotes circular economy principles by extending product life. You remember that position because they are used clothes that have come into the country, used textile that have come into the country, but that even although they are used, their life is still promoted by bringing them and being used by persons in Azania state. In your view, why do you think that this is not a complete defense? Or do you think it is a complete defense?
Thank you, Your Excellency. Allow me to take over from my learned colleague Nick Kimathi in answering your question. My name is Timothy Kamore. This, according to your question, it is the submission of the Republic of Azania that this is not a complete defense because the Textile Waste and Control Act targets the textile waste trafficking of the second-hand apparels. And the used textiles that are being exported from the global north to Azania, some of them are unwearable, which are termed as grade E, according to the grading requirements, and some of them are wearable and fall under the category of cream or grade A. And therefore, it is the submission of the Republic of Azania that the Textile Waste and Control Act will be able to curb the trafficking of these second-hand apparels that are unwearable and therefore are being disposed of in an inefficient manner, resulting to the pollution and the waterborne diseases which are affecting the vulnerable populations. That was also highlighted by Judge Charlesworth in the advisory opinion of obligations of states in respect to climate change, who are the women and the youth and the children that are the vulnerable groups. Thank you, Your Excellency.
Thank you for that response. Any of the international instruments or principles to support your position?
Thank you, Your Excellency. The Textile Waste and Control Act is an exercise of Azania's sovereignty under the principle number 2 of the Rio Declaration, where states are required to exercise their sovereignty to enhance measures that will not result into harm of harm of transboundary harm to other states. Furthermore, we are cognizant of the exceptions under the GATT Article 20, B and G in establishing measures that are justifiable and will not discriminate these second-hand apparel traders. Thank you, Your Excellencies.
I think that brings it to a close for Azania. And I will then now invite my colleagues to interrogate the position taken by CECA and present some of your questions for Council to respond. Judge Ogange.
Thank you, Presiding Judge. Counsel for CECA, when you were beginning your opening statement, the court notes that you concur that there is a need to change or how we think about climate change. Essentially, it means you also accept that Azania had a duty to regulate this sector. So the court wants to know, what is that is unlawful or that is not right about TWCCEA? Is it the purpose, its design, or its implementation?
Much obliged. As counsels for CECA, we do not contend every single aspect of the Textile Waste Control and Circular Economies Act. However, the specific sections that we do have a problem with are, number one, in regards to the extended producer responsibility, and number two, it is the digital traceability requirements. The grading requirements do in fact try to mitigate the effects of climate change, because in our part, we do concede that 35% to 45% of the textile apparels that we were importing into the country were in fact unsellable. However, once we get to the point whereby we are actually grading these apparels and they're coming into the country and they're actually sellable, the responsibility to ensure that their end of life cycle is seen to should not be our mandate. This will in fact put stringent measures on the small scale sector, going against Principle 12 of the Rio Declaration, which speaks to sustainable development. Further, in regards to the intergenerational equity, we do agree that there is a need for Azania to protect future generations. However, in the case of the fisheries jurisdiction, this was a case between the United Kingdom. It was decided that when it comes to intergenerational equity, it should be applied in such a way that it does not just come up with equitable solutions. However, these equitable solutions have to find a basis in the law. So these equitable solutions should not be infringing on the rights to economic development of these particular traders of this particular section. If that is, I hope that is sufficient.
Thank you for your response, Presiding Judge. Thank you. That is all.
Thank you,
Much
Judge.
obliged.
I will invite my brother, Judge Emukule.
Thanks, Presiding Judge. I have a question for CECA. The CECA Act, in my view, raises two fundamental questions: the right to trade by circular economy and the right to regulation by the state, regulation, importation of waste, etc. My question is, what are you asking the court to grant? Pronounce or regulating the trade or regulating waste?
Thank you, Your Excellency, for your question. To respond to your question, what we are asking from the court is the court to adopt an harmonized interpretation that protects interest, the economic interest, as well as that also promotes environmental protection. Your Excellency, what is the legal basis for you to come up with this decision? Your Excellency, Principle 12 of the Rio Declaration concerns itself on environment and trade. It provides 4 clear architects that we are inviting this court to adopt. The first architect is open international economic system. Inasmuch as it remains to be an obligation of the state of Azania to come up with a legislation, the legislation should have an objective to ensure there is an open international economic system. Your Excellency, to proceed, on the second architect, there should be no discrimination. Your Excellency, the third architect that we invite you to adopt in coming up with the interpretation of Principle 12 of the Rio Declaration, VC Article 20 of the GATT, is there should be a need not to come up with unilateral decisions. Your Excellency, this is also complemented with the fourth architect of the same principle of the Rio Declaration, which is on international consensus. But also, Your Excellency, what needs to be considered is what is the capability of the state of Azania? And the measures that it is coming up with, are they proportionate? And are there alternative ways in which the state can as well ensure there is protection of overriding interests? Your Excellency, if there were public participation as provided under Principle 10 of the Rio Declaration, then it means there could have been alternative measures that could have arose. One, for instance, there could have way in which both interest of both parties could have been addressed. It is our submission that in as much as the state is going to come up with an advisory opinion, let it be guided for the principle by the fact that climate change law does not replace other international laws, and it should adopt legislation that adheres to the four architects provided under Principle 12 of the Rio Declaration vis-a-vis interpretation of Article 20 of the GATT. I hope that answers your question, Your Excellency.
Thank you. Presiding Judge?
Yes, Judge.
That would be that question, one question to ask.
Thank you. Right. And for me, if you can hear me.
We can.
If the textile waste is imported by private fast fashion corporations rather than the state, and this is purely hypothetical, let me repeat it. If the textile waste is imported by private fast fashion corporations rather than the state itself, on what legal basis do you still attribute responsibility to the state?
Your Excellency, to respond to your question, it still remains to be an obligation of the state to come up with the legislation, and that is provided under Principle 2 of the Rio Declaration. But Your Excellency, there is need to also put into consideration while coming up with the legislation to consider Principle 6 of the Rio Declaration, which concerns itself on the common but differentiated responsibility. The ICJ advisory opinion in itself specifically talked about respective capabilities. In as much as there is also a burden that is also conferred to the CECA, which is now a third party, there is also a state itself. State cannot come up with unilateral measures, but it should come up with measures with also consideration to its capabilities. Excellency, the waste that is being alleged to have been in the state of Azania has actually presented an act that also acknowledges the transboundary nature in which they cause to the environment. To this extent, now it means that the decision should not be unilateral, but should also adhere to the global consensus. Your Excellency, this can be achieved as well under Article 7 of the UNFCCC, which incorporates the Conference of Parties, which is the COP to the UNFCCC. It gives an opportunity for international consensus in matters climate change. Your Excellency, we submit that in as much as there is also a burden that is also incorporated to the private actors, responsibility bears on the state to also ensure that the decision it takes to protect the environment are not unilateral in nature. I hope that answers your question, Your Excellency.
Thank you very much, Counsel. Yes, it does. Thank you. Court Assistant, I think from the bench, we have exhausted the interrogations that we had, and you may set out further protocols. Thank you.
Thank you very much, Presiding Judge, for those preliminary segments. Now we go to another segment where we call it the mandatory concession segment, where the presiding judge will basically ask two questions. The mandatory concession segment will take 5 minutes. You'll have 5 minutes, Counsel, to respond to the two questions, so divide your time intelligently. We'll start with the Azania side, presiding judge. Do you have those questions, Judge Mukule? Maybe I can just read them out for you.
Please.
Yes, so the first question that counsels will be interrogated on is, what is the weakest part of your case? Then the second question is, what is the strongest point made by your opponent? So presiding judge, you can take over that segment of mandatory concessions by inviting the state of Azania. You have 5 minutes to respond to both questions.
Thank you. Thank you. Azania, can you hear me?
Yes, Your Excellency.
Yes.
Loud and clear.
Thank you. The first question goes to Timothy Kamore.
Yes, Your Excellency.
What is the weakest link in your case?
Much obliged, Your Excellency. It is the submission of the Republic of Azania that the weakest link and part of our case is the short-term economic impact that the traceability requirements and the extended producer requirements will have on the informal workers, because these are workers that are used to the informal sector. However, Your Excellency, it was our submission that this short-term economic impact will later result into a benefit that will reduce the climate change impacts that has occurred on the women and the children. Because, Your Excellencies, as much as change is uncomfortable, the Republic of Azania cannot continue doing the same thing and expect a different result that will not cause pollution. And this is supported by the Rio Declaration and the United Nations Framework Convention on Climate Change. Thank you, Your Excellency.
Thank you. The reverse question is exactly opposite of that to your colleague. And what's your strongest point, Azania?
Much obliged, Your Excellency. The strongest point of our case is the compliance of Azania to the obligations of international law. More particularly, Your Excellency, the obligation of due diligence as per the ICJ advisory opinion that was rendered in 2020.
With your kind permission, Presiding Judge, I believe the second part of the question indicates what is now Azania to concede. What is the strongest point that CECA has made?
Essentially that. So what would you concede? What would
Thank you, Your Excellency, for the question. It is the submission of Azania that the strongest point of our opponents stands to be the limitations on their second-hand apparel trade. This follows the affirmation and the cognizance that they are entitled to economic rights as envisaged in the ICCPR and the International Convention of Cultural, Social, and Economic Rights. As a result of the measures that have been adopted by the state of Azania pursuant to the ICJ advisory opinion, there are certain measures such as the EPR and the digital traceability that have been put in place, which will see to it that certain limitations have been enforced on the second-hand apparel trade on the part of the informal traders.
Fantastic. Thank you. Thank you, Council Nick. Am I right?
Yes, that is right, Your Excellency.
Thank you. I think those are two questions that I think now we now go to Azania. What is, in your view, your strongest case against Azania?
Much obliged. With the kind indulgence of the bench, I'd like a clarification on whether you seek to know our strongest point or our much obliged. The weakest point of our case is the fact that the polluter pays principle 16 of the Rio Declaration, does in fact poke tremendous amount of holes in our case, as we are the ones who are in fact polluting the environment. The 35 to 45% of apparels that have been imported to the country that are in fact our obligation to actually ensure that the environment is protected against this and the environment as well is restored in this regard. However, we do not abandon our case, as we do further reinstate that the principle of common but differentiated responsibility does in fact apply in this case. According to the compromise, Azania have in fact acknowledged that circular economies are a potential vector in regards to transboundary harm, in transboundary environmental harm. As such, Principle 12 of the Rio Declaration mandates Azania to not only try and curtail the harm within our territory, but further to try and curtail the harm all the way from the source, from the importing country. Further, we as well do in fact clarify that it is the informal banning of this second-hand apparel that is in fact causing harm to the environment. The informal banning, to be specifically. If there were formalized measures of actually disposing of the second-hand apparel, then there will be no pollution to begin with. This is our position. I hope that is sufficient, Your Excellency.
May I follow that question, Council? Assume that the imported clothing was not banned or dumped. It was allowed to shredded and into microfibers, went into agricultural systems. Would that, does the legal injury become stronger or weaker for the supplier, CCA?
Pardon, kindly pardon the question, Your Excellency.
Supposing the clothing was not immediately burnt or dumped into the ground, and over time to shredded and into microfibers, which got their way into the rivers, etc. Would that lessen the injury cost to the environment.
Much obliged, Your Excellency. It is our position will not, in fact, lessen the effect of harm to the environment, as there should be appropriate measures of the end of life cycle disposal of this second-hand apparel. There should be government policies that the government does, in fact, implement to, in fact, tell people how they should be able to dispose the second-hand apparel at the end of their life cycle, as this second-hand apparel do, in fact, save the economy from higher levels of production costs. I hope that is sufficient, Your Excellency.
Thank you, Council.
Much obliged.
Thank you. Colleague Judge Ogange?
No questions, Presiding Judge. Thank you.
No
Next
questions
set.
either.
Right. Thank you very much. That closes the submissions for that segment. Now we go to another segment where the judges again will issue rounds of questions to the participants before we go to the rebuttals, and you'll have 7 minutes to answer. So make your answers short and to the point. Presiding Judge, can start with another set of questions from the judges, at least for the round for the sides of Azania.
Presiding Judge Helen Omonde, do you have questions for the Council for Azania?
At the moment, let me settle myself.
Thank you, Judge. Antoinette, Judge?
Thank you, Justice Semukle. Just before we proceed, I'm wondering, we've not heard from Kamara Castro on the second bit of the concession. That is the strongest bit of their opponent's case.
Please put the question, Judge.
Yes, I'm just indicating that we are yet to hear from Counsel Kamara on the second bit of concession. That is the strongest bit of their opponent's case. So we could probably give him an opportunity before we proceed to the next round.
Thank you, Judge. Counsel Kamara?
Thank you, Your Excellency, for the opportunity. Before I proceed, I beg to mention that it is raining in my background. And could you please clarify whether you are able to hear me and whether I'm audible?
I can hear you. You are audible.
Thank you, Your
My fellow
Excellency.
judges? Yeah.
Thank you, Your Excellency, for that clarification. Your Excellency, the question on what is the strongest point made by our opponent. Your Excellency, we submit that the opponents have submitted a strong point based on the reliance on Principle 2 of the Rio Declaration, whereby they have stated that it is necessary based on their sovereignty principle to come up with legislation. Your Excellency, this is also complemented from the fact that international climate change is considered as a global common good. From this fact, then it means it brings up the erga omnes obligation, which requires states to act. And this action can also be complemented from the lens that it can also lead to states adopting their own measures to ensure there is environmental safeguards. However, in contrast, Your Excellency, we submit that the advisory opinion rendered in 2025 on state obligations on climate change clarified the question on lex specialis principle. Your Excellency, to quote the specific paragraph, under paragraph 171, the advisory opinion specifically stated that climate change law does not replace other laws. We submit that indeed it is a strong argument, but still we maintain the position that the lex specialis principle can still be used to counter that strong argument. Your Excellency, I humbly submit.
Thank you.
Thank you. Lady Justice Omondi?
Nothing. Add, Your
Thank
Lordship.
Thank you. Our moderator, court clerk, next session, next segment.
Yes, the next segment that we are getting into again will be where now the judges will issue hypothetical questions to the participants, either with altered facts, altered doctrine, to test whether your legal argument will survive altered facts. So Justice Emukule, you can lead now again another round of hypothetical questions. You can start with the side of Azania.
Azania, one question from me. Posting the ICJ opinion, advisory opinion, was binding. Would that alter the position, the claim against the claim by CECA?
Thank you, Your Excellency. To your question, the response of the Republic of Azania is that if, in case the advisory opinion was binding, our claim would not have been altered, for the simple reason that the advisory opinion does not create new law, but rather it authoritatively articulates existing international law rules and customary international law rather lex lata on the legal issue decided, and therefore it must be understood as its content is binding due to its lex lata nature and not because it creates new law. Thank you, Your Excellency.
Thank you, Counsel. Judge Ogange?
Thank you, Judge. My question to the state of Azania. Assume that Azania required all importers to pre-sort, certify, and trace textile shipments before getting into Azania, but the same environmental harm still occurred. Has Azania discharged its legal obligation? Hoping I'm clear.
Thank you, Your Excellency. You are loud and clear. In response to your question, allow me to state before this honorable court that the obligation of due diligence is an obligation of conduct and not result. That is what was stated in the ICJ advisory opinion, which authoritatively reaffirmed that position and that standard. Now, for your question, if harm were to occur, but Azania had taken the necessary measures to ensure that it has used all means at its disposal, we cannot hold Azania to be responsible for that harm. Reason being, the standard and conduct of the due diligence that is imposed on Azania is and should be of conduct. I hope I have been satisfactory in the response I've given, Your Excellency.
Just to probe a bit further, do you wish to rely on any authority to support your answer?
Pardon, Your Excellency.
Any authority that comes to mind in support of your answer?
Thank you, Your Excellency, for that question. When looking at whether or not the standard and conduct of the obligation of due diligence should be of conduct rather than result, I can make reference to the ICJ advisory opinion.
We'll leave it at that. Thank you for your response.
Next
Presiding
question.
Judge.
I'm trying to.
Does Lady Justice Helen Omondi has a concern?
Yes, if I can be heard, can I be heard?
Perfectly.
Yes.
Thank you. And this is for Counsel for Azania. You are aware that there are instances where countries have reservations to treaties, to conventions, and international instruments. Are you familiar with that?
Yes, Your Excellency. We are aware that there are countries that are not signatories to the climate treaties and conventions.
Would the situation have been any different if Azania was not a signatory to one of the conventions?
Pardon, Your Excellency, please clarify your question. You could not be heard audibly at the first part.
Can you hear me now? Would the situation, the position that Azania took have been any different if Azania had had reservations to the key international conventions, the covenants that address socioeconomic rights and civil rights? Would it have been any different?
Thank you, Your Excellency. The position of Azania would not have been any different for the reason that, as was articulated by Judge Shiu in the advisory opinion of the legal obligations of state in respect to climate change, that there's a direct relation between the climate change obligation and the due diligence obligations under international law, which was established in the pulp mills case and the transboundary harm rule under the 1941 trade smelter arbitration. And therefore, Azania would still be bound by customary international law to establish measures within its jurisdiction that will not result into transboundary harm, and therefore would not have an excuse also under the principle of common but differentiated responsibilities to enact measures within its capacity as a state to mitigate the harm. Thank you, Your Excellency.
Thank you. Thank you. Brian?
Yes, now I believe that does it for the state of Azania. We can now move to the last set of questions to the stakeholders, CECA. Presiding Judge.
Lady Justice.
Thank you, Judge. For CECA, assume that Azania receives 200,000 tons of second-hand clothing annually under the label of reusable textiles. Evidence later shows that 65% of those imports are unsellable and are dumped in Azania within weeks. At what point does this cease to be lawful trade and become unlawful transboundary waste dumping? Is that okay, or do I need to repeat the question, CECA?
Much obliged, Your Excellency. I do apologize. Kindly repeat the question. I'm struggling to hear you kindly.
The question is,
yes,
assume that Azania receives 200,000 tons of second-hand clothing annually under the label of reusable textiles. Evidence later shows that 65% of those imports are unsellable and are dumped in Azania within weeks. At what point does this cease to be lawful trade and become unlawful transboundary waste dumping?
Much obliged. That is much more clear, Your Excellency. Thank you for repeating the question. The point that it ceases becoming lawful trade and becomes potentially transboundary harm to the environment is whereby when you find that more than 50% of the imports are actually going towards damaging the environment. This is no longer legitimate trade as it qualifies under the exceptions of Article 20 of GATT. So it is necessary to protect human health and it is necessary to protect the environment. And as such, the government should actually take necessary measures such as grading and as well as proper disposal measures so as to make this trade legitimate once more. I hope that is sufficient, Your Excellency.
Thank you for your response.
All right, that is well in order. So that marks the closing session. That marks the end of that round of questioning. Now we go to the last session, which is the rebuttals. And the rebuttals, you'll have only 90 seconds. And for the rebuttals, the single most, each side will have 90 seconds for the rebuttal, and the rebuttal is limited strictly to one issue only. And that issue is, what is the single most serious legal weakness in your opponent's case? What is the single most serious legal weakness in your opponent's case? Repetition of submissions shall be permitted at this point. You have only 90 seconds. Presiding Judge, I believe we can start with the CECA side this time round.
CECA,
Yes.
you've had a question. What is single most serious weakness in your...
Thank you, Your Excellency, once again for the opportunity to address the court. Your Excellency, the most weakest legal submission made by our opponents is on the question of proportionality, whereby the opponents, based on their submissions as summarized, submit that indeed the enactment of the Act remains proportional based on the objectives and also based on the expected legitimate expectation that it has in regulation in regard to environmental protection. Your Excellency, we submit that the law allows for development and environment. Your Excellency, to anchor on point of law is that Principle 25 of the Rio Declaration speaks to the fact that development and environment are interdependent and they're indivisible. Your Excellency, inasmuch as a state can come up with a law that is proportionate and it is necessary, it is important to underscore the fact that there is interdependent nature between environment and trade. Your Excellency, we also submit that this is also anchored based on the state of the nation and also those who are involved. Your Excellency, Principle 20 also rebuts that argument from the fact that women are also at the integral point of the development and trade. And to this extent, we submit that that is the weakest point made by our opponents. I rest my case. Thank you.
Thank you.
And now go to the Azania side.
Azania?
Thank you, Your Excellency, for this opportunity to address the court on the weakness of the Coalition of Ethical Circular Apparel argument. It is the submission of the Republic of Azania that the weakest and most unholy claim in their submission was the reliance of the lex specialis question in the 2025 ICJ advisory opinion, where they used the argument to claim that the Republic of Azania is treating the climate change treaty above other international rules such as trade law and environmental law. However, the lex specialis rule was clarified by the ICJ advisory opinion under page 56 to 58 that there is no inconsistency between climate change treaties and the international rules of law, because when making reference to the United Nations Framework Convention and the Paris Agreement, there is mention of other international rules and principles in their preamble. Another inconsistency is the lack of clear alternative measures in regulating the trade in second-hand apparel. And it is therefore the submission of the Republic of Azania that this court clarifies that states such as Azania must take positive steps on these particular sectors as a matter of obligation in respect to climate change. And as we rest our submission, Your Excellencies, I would like to quote the words of Barack Obama on climate change, where he said that we are the first generation to feel the impact of climate change and the last generation that can do something about it. And therefore we rest and submit and yield the floor back to the bench.
Thank you, Counsel.
Thank you, Presiding Judge. That marks the end of the sessions for semi-final 1. With that, we shall request the judges to retire to the chambers to deliberate. The rest we stay on call as we wait for the judges to come back with their judgment and we see which is the first team to win a place in the finals. Thank you. Judges, we can humbly retire and meet at the chambers.
Thank you.
Participants, you can switch on your cameras. We are back with the determination of the court. But as usual, before we issue the court's determination, before I give it back to the presiding judge for delivery of the determination, I will give you your responses. We'll start with the Catholic University of Eastern Africa, representing Azania. For precision and clarity, Nick Kimathi, we start with you. Are you on the platform?
Yes, I am.
Yes, I can see you. Thank you. So the bench indicates you had a strong opening. The bench also indicates you are clear in your reasoning. The bench further indicates and notes you are well versed with practical realities. The bench further notes that you captivated them well with your arguments and you captured their attention. The bench further notes that you are quick in your responses, and indeed you are very impressive. For your counterpart, Timothy, the bench indicates you had excellent grasp of the principles and the laws at hand. The bench further indicates that you responded very well. The bench further indicates you have good oratory skills. The bench notes that you are well versed with laws and principles. And the bench also notes that you are confident. For Nick, from my own personal observation, I could indicate that you got intimidated by Judge Antoinette at some point when she was exerting pressure on you, and it was evident from how even your tonal variation went down, but you picked up later. So that was part of the training, to exert pressure on you, so that you can know how court etiquette is. So you should not yield to that exertion from the bench. You should just maintain your composure and maintain your confidence. To your counterparts, JKUAT from representing CECA, that with Castro, the bench indicates indeed you are very confident. The bench further indicates you are a quick thinker. The bench further notes that you are well read in different areas, hence you are able to respond quickly to a variety of issues. The bench further notes that you have a way of quickly attending and planning yourself to respond to issues. You can patch up quickly. That's what the bench indicates. The bench also was impressed during your concession segment. You also gave a contrast, which was very impressive, and you should keep it up. For your counterpart, Levis, the bench indicates you are confident, you are precise in your communications, and your performance in the concession segment was also great. With that, that ends the comments for semi-final 1. I give it back to the presiding judge for delivery of the determination. Welcome, presiding judge.
Thank you very much, Dr. Brian, and to the two teams that were before us today. The issues that we considered were the precision and clarity in presentation, your responsiveness to questions that were presented, the doctrinal accuracy and legal counsel, your quality of legal research and distinctions, the performance, especially in the concession segment, and your response to the judicial hypothetical situations that were presented to you. And we were impressed by all of you regarding your courtroom discipline, your composure, and your professionalism. It was a very tight outcome that it took us quite a while because both teams are very strong, very, very well. Whoever is giving you your training has done excellent job for both teams. And so this was a very close one. For CECA, represented by CUEA, the score is 82%. And for Azania, represented by JKUAT, no, it's the other way around.
Yes,
yes. CECA, represented by JKUAT, the score is 81%. And for Azania, represented by CUEA, the score is 82%. So CUEA carries the day, but JKUAT, you are a really strong contender, and well done to both teams.
Thank you very much, Presiding Judge. Thank you very much to the contestants. Indeed, this was a very tight race. As you can see from the comments, there's no negative comment. There's nothing area for improvement. Everything is excellent, excellent, excellent for all of you. And we thank you so much. JKUAT, you put on a spirited fight from the beginning up to now. CUEA, once again, great job. You joined this competition at the last minute, a day before it began, and you've made it all this far. We thank you very much for this. As we always indicate, there are no winners, there are no losers. This is a learning curve. All of us are learning in one way or another. Stay on call, stay on our platforms. We still have more opportunities. Before we pen off, I'll give you an opportunity to say something, Castro.
Thank you. I mean, this is quite heavy on me to say, but I don't know what to say. So it has been a great time. Thank you.
Levis?
From the very beginning, I started by thanking you for the opportunity. So till the very end, I'm going to as well thank you for the opportunity. Yeah, it has been an honor presenting before the judges that we've been presenting before. And it's unfortunate that the journey to Addis Ababa has been cut short.
Nick?
Thank you for this opportunity. Allow me to first immensely congratulate JKUAT. They have given us a good run for our money, and I've learned a lot. They've enabled us to put our best foot forward. And also to the bench, we are very grateful for having gotten this opportunity to appear before you. We do not take it for granted. And to Brian, the organizer, thank you for giving us this opportunity in the very last minute.
Timothy?
Thank you so much, Brian. I would also like to thank the organizers in the same vein and thank everyone who has been supportive of us in this journey, and thank God for how far we've come. And in the same vein that Nick has said, it has not been easy. I think that adage of the higher you go, the cooler it becomes is very true, because it has been very competitive this round and the last quarterfinal. And we want to thank JKUAT for the submissions. And I'm sure at this point, everybody is well versed with climate change than they've ever been before, specifically me. At some point, I remember back when I was still a young boy, I saw climate change as a not very major issue, but right now it seems like it is actually a crisis that needs to be handled well. So thank you so much. Yeah.
Nick, your hand is up, or it's accidental?
No, it's not accidental. Before an opportunity perhaps is given to the judge or we pen off, allow me to thank our Moot court coordinator as well, who is on the platform, Madam Frida Kabatsi. She has walked with us every single step of this journey, and I'd be doing a very great injustice if I were to not mention her. Yes, thank you so much.
Thank you so much. So semi-final 2 will take place on Saturday, the 2nd of May, 2026, between University of Zimbabwe, representing Azania, and Herbert Chitepo University, representing CECA. If there are no further issues from the bench, the semi-final round is concluded. The court is funked as officio. You are free to leave the platform. You'll get communication from your WhatsApp group on the next steps, as well as the evaluation rubric, which has constituted to your marks today. You'll also get it tomorrow as usual in the morning in your emails so that you can see where you need to improve. Thank you very much. You are free to leave the platform. The court is funked as officio. Thank you.